Controversy has erupted over the NSSF contributions. The questions that are coming up: can the Federation of Kenya Employers ignore a decision of the Court of Appeal? Can citizens who have gotten a reprieve of contributing 200 shillings per month be told no, continue contributing as you have been contributing from 2023? The economy is bad. The pain of employees is terrible. What did the judges of the Employment and Labor Court give? This was an application that was dated, it is an application dated 14th October 2022 for stay. It is being determined on 29th May 2026, 4 years down the drain. So because the Senate was not involved, they declared that NSSF Act unconstitutional, null and void. Section 27, Article 27 of the Constitution talks of equality. In this act, if you are unregistered, you could not access the funds. You could not access the services. This was discrimination. The judges found out that this section 19(2) was unconstitutional. This is where the judges made their decision. NSSF was always talking about that if there is no stay, NSSF will be destabilized. NSSF will collapse. Employees will collapse. They never presented any evidence. For now, the law as it is, the workers must only be deducted 200 shillings. Is this judgment of the Court of Appeal a reprieve? Welcome to Trending News. On Monday, Wakili Danstan Omari from KOTU News wishes you a good working day. Controversy has erupted over the NSSF contributions. People from different quarters are talking differently. We have several stakeholders in the labor sector raising a lot of noise and a lot of dust. We start with the Senior Counsel, Kanjama, the president of the Law Society of Kenya, where I'm a member. Senior Counsel, Kanjama, the president, has said that the law must be applied. The decision of the Court of Appeal must be upheld, that you cannot select which provisions of the law you comply with and which ones you don't comply with. Therefore, Senior Counsel, President of the Law Society of Kenya, agrees with the decision of the Court of Appeal. 2, we have seen the Secretary General of KOTU, Francis Atwoli, in his press release castigating the Court of Appeal badly. In his advert put in the press, he's saying that the Court of Appeal was dealing with an application that had already been spent, that the matter had already gone to the Supreme Court, and the Supreme Court had rendered itself, on which matters it remanded to be dealt with at the Court of Appeal. And therefore, the application for stay, one for 2022, was already overtaken by events because a judgment had already been issued. And therefore, he and KOTU are seeking an explanation and a serious indictment on the Judicial Service Commission and the Court of Appeal. That is the version of Atwoli and KOTU. The third actor in this matter is the Federation of Kenya Employers. The Federation of Kenya Employers, by its boss Mugo, has raised very serious issues. To them, they are saying that the position taken by the Court of Appeal is going to destroy completely the labor sector. He says the Court of Appeal has declared unconstitutional and refused to grant a stay, which means the contributions are going to come from 6% to 200 shillings. She says, and she has advised employers to continue deducting employees at a higher rate of 6% and above, so that the government can get money, dividends can be paid, and other benefits can accrue. So, the questions that are coming up: can the Federation of Kenya Employers ignore a decision of the Court of Appeal? Can citizens who have gotten a reprieve of contributing 200 shillings per month be told, no, continue contributing as you have been contributing from 2023? The economy is bad. The pain of employees is terrible. The pain of employers who contribute some percentage to the employees' deductions is terrible. Many businesses have closed. Many employees have been declared redundant. Many employees' families have died. The marital dispute in homes is because people have no food to put on the table. Children are not going to school. People, bodies who have died, the owners cannot be able to meet hospital bills. Is this judgment of the Court of Appeal a reprieve? What is this judgment? Court helicopter crew Vivian had to go to look for this from the Court of Appeal, and we found it, and here it is, and that's why we are doing it Monday very early. This is civil application number EVE 656 of 2022. The quorum is Justice W. Karanja, the acting president of the Court of Appeal, Justice Minoti, and Justice Nyamweya Pauline, all of them judges of the Court of Appeal. This is a case between National Social Security Fund Board of Trustees and Kenya Tea Growers Association and 14 others. Being an application for conservatory orders staying the judgment and decree of the Employment and Labor Relations Court of Kenya at Nairobi, there were 3 judges of the Labor Court: Justice Nduma Nderi, Justice Wasilwa, and Justice Mbaru, all of them judges of the Employment and Labor Relations Court on 19 September 2022. This is petition number 38 of 2014, which was consolidated with petitions number 35 of 2014, 34 of 2014, 49 of 2014, and 50 of 2014. So the questions that were there: what did the judges of the Employment and Labor Court give? The judges, the 3 judges, Wasilwa, Nduma Nderi, and Justice Mbaru, gave the following. In paragraph 3, the impugned judgment partially allowed the consolidated petitions as follows. 1. The court ruled that NSSF Act applies to county finances and planning because county governments, like the national government, are employers bound to match worker contributions from local revenue funds. That is the first thing, that NSSF Act equally applies to national government and local government. 2, they are supposed to match. If an employee is deducted 5,000 shillings, equally the employer is supposed to match that. Number 2, the judges said the court found that the Senate was not involved in the legislative track. Consequently, the act was declared unconstitutional, null and void. The 3 judges of the High Court found out that and the Senate was not involved because county government, they are supervised and funded by the Senate. So because the Senate was not involved, they declared that NSSF Act unconstitutional, null and void. The three judges also found that the NSSF Act heavily favored the NSSF over third-party insurance providers, violating the Competition Act that threatened to stifle existing pension frameworks. Number 3, they found out that the NSSF Act favored NSSF. Yet, there are very many providers for pension funds. Third parties are involved. So, under the Competition Act, in this country, everybody is supposed to compete equally. NSSF had some advantage in that act, and therefore, to bring equality and fairness, the 3 judges found out that that was wrong, and that's why they declared it unconstitutional. Number 4, on the usurpation of the Salaries Remuneration Commission mandate, the 3 judges found that that under Article 234, the Salaries Remuneration Commission retains the sole authority to set and review remuneration drawn from public funds. Section 13 of the NSSF Act, which granted this power to the Cabinet Secretary for Labor, was declared null and void. So, under the Constitution, all matters salary of public servants, both at the national level and the county level, that is a preserve of the Salaries Remuneration Commission. But under the NSSF Act, this mandate was stolen from the Salary Remuneration Commission and given to the Minister, Cabinet Secretary for Labor. The judges, the 3 judges, found this as illegal, unconstitutional, and declared Section 13 null and void. 5. On the overarching restraints on public services, the court found no legitimate purpose for Section 19(2), which barred unregistered citizens from accessing public services. This section was struck out for violating fair administrative action and equal protection laws. Section 27, Article 27 of the Constitution talks of equality. In this act, if you are unregistered, you could not access the funds. You could not access the services. This was discrimination. The judges found out that this Section 19(2) was unconstitutional when it was put across in competition with Article 27 of the Constitution. 6. With regards to violation of choice, the court found out that the mandatory requirement to enroll in SSF, despite having superior private arrangements, was a justifiable limitation on free choice. Under the NSSF Act, it was mandatory for everybody to be registered there. Private entities like Danstan Omari and Associates, they will be having their own private pension scheme. Under the Retirement Benefits Authority, most multinational companies, most blue chip companies, most banks, most private entities have their own pension scheme. So they were now being forced that even if you have your scheme running, you must also join NSSF, which is a double tragedy. Why should you have your own scheme, which is superior, then you are dragged into this? Out of this, the court found that this is against the law. The law says free choice. You choose whether you are going. For example, you cannot be forced to listen to other medias and you are told, Court Helicopter, don't watch it, don't listen it. Or you cannot be forced to watch only Court Helicopter. The freedom, the choice is yours. That is what the Constitutional said. These 6 grounds, after the judges said this, the NSSF and the board, through Dr. Julius W. Karangi, the chairman, made an appeal towards the Court of Appeal. In paragraph 9, he says, aggrieved, the applicants lodged a notice of appeal dated 26th September 2022 against the said decision and followed it with this application seeking to stay execution of the judgment. So what was taken to the Court of Appeal is an application to stay implementation of the judge's decision from the High Court. Let us see what the judges found out. The judges, in paragraph 30, among the reasons they raised, NSSF raised, is about jurisdiction, that the court had no jurisdiction. Paragraph 30, the judges say the jurisdiction of this court in an application under Rule 5(2)(b) is original, discretionary, and unfettered, though it must be exercised judiciously and in the interest of justice. And this was the decision in Stanley Kang'ethe Kinyanjui versus Tony Keter and 5 others in 2013. The court stated, the applicant must satisfy both limbs. First, that the appeal is arguable, and second, that the appeal will be rendered nugatory if stay is not granted. An arguable appeal is not one that must necessarily succeed, but one that raises a bona fide point worthy of consideration. The nugatory aspect considers whether, if stay is not granted, the appeal will be rendered worthless, futile, or incapable of being reversed, or whether damages would reasonably compensate the aggrieved party. NSSF argued that the court does not have jurisdiction. The judges have responded that under Rule 5(2)(b), they have unlimited jurisdiction. 2, they said they will consider this application based on 2 principles. 1, the principle whether the appeal is arguable. And they have said that it does not need to succeed, but is it something that is worth listening? 2, whether if it is not heard, it will be nugatory, which means, for example, if you are not heard, for example, your house is being demolished, the court, if it does not hear you and give you a stay, your house will be demolished. Can you be paid, for example, damages? Those are the questions the court looks at. If damages will pay you back, you will not get anything. But if it is nugatory, it can cause serious prejudice. The Court of Appeal will listen. Paragraph 31. The twin principles accordingly guide our determination as to whether the intended appeal is arguable and whether the intended appeal will be rendered nugatory if stay of execution is not granted. Paragraph 32. On the limb of arguability, we have come to the conclusion that the issue of jurisdiction of the Employment and Labor Relations Court to have heard and determined the petition before it is no longer a live issue, having been heard and determined by the Supreme Court on 21st February 2024 in the Kenya Tea Growers Association and 2 others versus the National Social Security Fund, Board of Trustees, and 13 others, petition E004 and E002 of 2023, consolidated in KESC 3. So the question whether the Employment Court had jurisdiction was determined in the Supreme Court. So the Court of Appeal said there is nothing about it. Then in paragraph 33, I think this is where most of the confusion is coming from. Let me read it. However, Without prejudice to the foregoing, the broader context of this dispute cannot be ignored. Our cursory perusal of the Memorandum of Appeal revealed that the appeal is not frivolous. The judges found out that the appeal is not frivolous. Why? Some of the issues raised include whether there was misconception of social security. The applicant contends that the learned judges wrongly erred by assuming that the NSSF Act 2013 was a social assistance legislation. So the judges we are therefore satisfied that the intended appeal is arguable. The second appeal, that is where they lost badly. As to the second issue, whether a successful appeal could be rendered nugatory, the judges in paragraph 34 said, apart from frequently repeating the assertions of likely destabilization and the inability of the applicant to perform its function due to the legal lacuna, the applicant provided, and I repeat, Vivian highlighted this, the applicant provided no evidence or submissions as to how and to what extent the applicant could be stabilized. No accounts were produced by the applicants to support the destabilization theory. We are therefore not satisfied that the applicant has shown that a successful appeal on a judgment and decree will be rendered nugatory if no stay is granted. This is where the judges made their decision. NSSF was always talking about that if there is no stay, NSSF will be destabilized. NSSF will collapse. Employees will collapse. They never presented any evidence. They never presented any accounts. They never showed any charts or annexures showing how NSSF is going to collapse. They were just talking. It was hot air. They never presented materials before the judges. And based on that, the judges found out that there was nothing. The judges in paragraph 35 say, in the end, and since the applicant has only satisfied one of the two limbs necessary for grant of the order sought under Rule 5(2)(b) of this court's rules, we find no merit in the notice of motion dated 14th October 2022, which is hereby dismissed with costs to the first and second respondent and the second interested party. Paragraph 36, finally, we render our unreserved apology for the delay in delivery of this ruling. The application escaped the attention of the drafting judge until a few days ago. Any anxiety or inconvenience occasioned by the delay is regretted. The judges are apologizing. This was an application that was dated, it is an application dated 14th October 2022 for stay. It is being determined on 29th May 2026, 4 years down the drain. But they have explained that the drafting judge inadvertently did not see or remember to do that job. The judges of the Court of Appeal can also apologize. The judges have taken responsibility. They gave this judgment on 29th day of May 2026. That is the acting president of the Court of Appeal, Justice W. Karanja, Justice K. Minoti, and Justice P. Nyamweya. This is the decision of the court. It has raised a lot of issues. Senior counsel Amin Nasir has posted about this issue. Senior counsel, the president of the Law Society of Kenya, that is Kanjama, has posted on this issue. Senior counsel Nelson Havi, the former president of the Law Society of Kenya, has castigated the judges seriously. from KOTU, our position, we don't take stands. We bring you the law. We have brought you the position of those criticizing the judges. We have brought you the position of the judges. We have read you. This is the decision that came from the Court of Appeal. For now, the law as it is, the workers must only be deducted 200 shillings. That is the decision of the Court of Appeal. Can anybody afford to ignore the Court of Appeal decision? If you ignore the Court of Appeal decision, you will face what is called contempt of the Court of Appeal decision. You'll be jailed for contempt. Can you differ with the judgment of the court? Yes, you can differ with the judgment of the court. But the court orders are not aesthetic orders. They are not a paper. They are not tissue papers to be discarded. Anybody aggrieved with this decision should move to the same Court of Appeal for review. On Monday today, that's why we have done it. All these who are making noise should move to the Court of Appeal for review of this decision if they have new facts. 2, or move to the Supreme Court for an appeal, and in that appeal apply to stay this decision of the Court of Appeal. Anybody trying to advise any Kenyan to disobey a court order, that is making Kenya a banana republic. Kenya is governed by the court orders. If you don't agree with the court order, you must comply or challenge to vary that court order. It's not on your mandate to arrogate powers that have been given to the judges of all layers, whether it is a magistrate's court, whether it's a high court, whether it's a Court of Appeal, whether it's a Supreme Court. Any court order must be respected. Wakili Danstan Omari telling you the importance of obeying court orders. Keep watching. We bring it as it unfolds from KOTU every time.